Good afternoon, everyone, and welcome to today's webinar. My name is Talia Warner, and I am with the Houston Immigration and Legal Services Collaborative. At the beginning of last year, a collaboration was created with our partners that includes Chloe Walker with the Children's Immigration Law Academy, who's on our call today, Marissa Pearson with Justice for Our Neighbors, Jessica Howton with Tahirih Justice Center, and Rosalie Hyde with the Houston Galveston Trauma Institute.
Oh, I was waiting for them.
The focus of this collaboration was to bring you a webinar series for attorneys and clinicians to address best practices in providing forensic evaluations for immigration cases. Today, we are hosting webinar number 3 of the series titled Setting Up Forensic Evaluations. This webinar will focus on best practices for setting up an evaluation and collaborating with mental health evaluators. Our presenters will explore how and when to use a forensic evaluation based on legal needs of the case. We will also delve into the components of a mental health evaluation and review different types of expert evaluations and licensing requirements. Today's presentation is led by Jessica Howton, who's the managing attorney at Tahirih Justice Center, and Rosalie Hyde, whose newest publication on forensic evaluations is included in the recently published Handbook of Refugee Experience. This webinar is being recorded and will be available on our website. PDFs of the slides will be shared with those who registered. Please ensure that you are muted during the presentation. Please use the chat box to enter your questions and comments, and we will answer your questions during our Q&A section. If you are on the phone, please hold your questions until the end of the presentation. And without further ado, I present to you Jessica Howton and Rosalie Hyde.
Great, thank you, Talia. Let me get our PowerPoint up and we will get started. Here we go. All right, as Talia mentioned, this webinar is going to cover setting up of forensic evaluations. The idea is how you can successfully obtain this critical piece of evidence for your immigration case. As Talia mentioned, it's part of a series, and thank you for the great introduction. So what we're going to cover today. So first, we're going to focus on what is an expert, both according to the Immigration Court and also USCIS. Then we'll go into what is a mental health evaluation, the different components that go into it, and additional information when doing assessments. And then we're going to touch on how to actually work with your mental health expert. And then lastly, next steps. All right, so do you want to add anything to the introduction?
Well, I just wanted to say that we're trying to really break this down in this series of webinars so that both attorneys and clinicians who are interested can really understand in some greater depth both the purpose of the evaluations, what they are, how to really get a good evaluation, how to do a good evaluation. So we're breaking this piece down so that you really have a better understanding of how to set it up.
That's right. And without setting yourself up for success, it's likely you're going to get the evaluation you need. So we're hoping that by the end of this webinar, you know how to do just that. So let's start with what is an expert. So an expert in immigration court is there to assist the trier of fact and understand things outside that person's knowledge. So we can't expect all the adjudicators at USCIS or the immigration court to understand trauma. And in fact, to assume that they do is a mistake. Your expert either has scientific or technical or other specialized knowledge that will assist that person to understand that evidence. While the federal rules of evidence aren't mandatory in immigration court, they're still persuasive. And that language came from the federal rules of evidence. So if you can meet that standard, then likely you can meet the standards of an immigration judge. So let's talk about what an expert is not. An expert is not there to opine on the law. They're not there to replace the adjudicator's opinion or findings. There's a limited exception to that, and if we're talking about foreign law. So if part of your case is to prove what the law is in another country, then obviously an expert witness is able to do that. But your expert witness, whether they are medical, mental health, country conditions, should not be there to talk about what the law is in the United States. That's your job in your persuasive brief, and then the judge's job when making a decision. So they're not supposed to interpret the law applying to the specific facts of the case, and they're not supposed to make credibility findings. Now, they can lend their expertise and give their opinion, but it cannot supersede a judge's decision. So further into who can be experts. When an adjudicator, whether at USCIS or Houston or an immigration judge, is deciding somebody's an expert, we're presenting their experience, their training, their licensure, and their degrees. And so we're looking at the whole picture and applying it specifically to one case. Just because somebody is considered an expert in an immigration case in the past doesn't mean that they're an expert in the immigration case you have before going forth at that moment. So once an expert does not always make an expert when it comes to immigration.
And these are generalized, we're kind of, in terms of setting up what a generalized expert is, and we're going to get more specific about mental health experts.
In fact, the immigration practice manual for judges actually only reference experts one time, and it's to talk about the requirement of having their CV or resume in your witness list. So it shows from the back that the importance is proving that this person qualifies as an expert. So when trying to get somebody to be qualified as an expert in immigration court, essentially the judge is going to look at three things. They're going to look at the relevance of the expert testimony to the case at hand. Again, just because you're an expert in an immigration case in the past doesn't mean you're an expert in this case.
Could you give some kind of legal specificity on that, an example for that? How someone might not be an expert in a present case that were once an expert?
Sure. So if somebody, if somebody's expertise is around working with survivors of sexual assault, and they've been an expert in an asylum case in the past, they've been an expert in a cancellation case to talk about hardship for somebody who has suffered sexual assault, and they've been found to be an expert by immigration judges in the past, it doesn't mean that the next immigration judge will think that they're an expert if they're there to talk about the dynamics of labor trafficking or something like that. Okay. And so this is where, and we'll get into this more in this webinar and also in future webinars, but simply being, experts aren't recognized as a general statement most of the time. And if you are trying to present that, you need to be very careful as to what you're trying to say this person is an expert in for your case, and it should be very, very clearly connected to what you want to prove. And so just something to keep in mind.
And to have those discussions with your expert.
Exactly. And so I already mentioned the importance of having a resume or a CV, and that's one of the key pieces of proof that you have about somebody's expertise in addition to their testimony. And the judge will also look at the reliability of an expert opinion. So they'll look at how they came about writing their report or getting their opinion. They might ask about what the normal process or procedures are to do an evaluation, and if they followed that. They might look if there's any bias. Is there any relationship between the evaluator and the attorney, or the evaluator and the client? Was the evaluator paid? Is this their profession to, and are they only willing to do it for one side of the case, right? So whether the judge thinks that there is some sort of bias that might exist can affect the reliability of that expert opinion. And this is something we're going to talk about in future webinars as well, but it's important to remember that just because somebody can be admitted into court or as part of their USCIS case as an expert opinion, it doesn't determine how much weight that the judge is going to put on what the expert says. That is something else. That's a discretionary right that the judge has, looking at all of these different pieces. So even if a judge thinks that maybe the expertise of this one person is not the most relevant, they can still allow the expert to testify. They just might choose not to put the same amount of weight onto the expert opinion as they would for somebody else.
And it could work the reverse, actually, if the judge didn't experience the expert as that specialized, but then when on testimony, it might be reversed and the judge understands the depth of the evaluation and the expertise.
Right. So for much of this presentation and for future webinars, we're going to be talking a lot about how to work with your expert in prepping for court and presentation at court and things like that. But I don't want to overlook the fact that an expert evaluation can be incredibly helpful just for an affirmative case that maybe has no court proceedings part to it at all. So if you are working with a case that, a U visa case, a T visa case for victims of human trafficking, for example, that are just going before USCIS, an expert evaluation, a written expert evaluation, can be an incredible piece of evidence in showing that your client qualifies for relief. And so what you see on the screen are actually quotes from the USCIS Adjudicator's Field Manual. There's a lot of similarities to what we just talked about for immigration court. You know, essentially that the rules of evidence are not binding, but they're incredibly persuasive. So if you're following those 3 points that we talked about just a second ago, the relevance, the qualification, the reliability, then that person should be considered an expert in your USCIS case as well. And there's great practice pointers out there, whether through AILA or other organizations, about using experts when it comes to USCIS cases. And for those maybe who are not attorneys,
for the non-attorneys.
when I say USCIS, I mean U.S. Citizenship and Immigration Services. So the majority of this presentation is going to cover mental health experts and mental health evaluations. But we would be remiss if we didn't also highlight that there are other experts that can be involved in your immigration case. So you could have country condition experts, you can have other medical experts, whether to do a SCAR evaluation, gynecological evaluations, or evaluations on just the general health and well-being of that person. And then what we're going to do, though, for the rest of this presentation is dive into mental health evaluations and different experts and expertise that can be used to provide you that key piece of evidence.
And because the mental health evaluation is in such depth, you often might get a recommendation from the mental health expert to get a country conditions expert or to get a medical expert to examine scars or a gynecological exam, etc., depending on the story or the experience of the client.
That's right. And that goes to something that I said earlier, that your expert has to be an expert in what they're talking about, right? So if you have a mental health evaluation that starts going into country conditions, that speaks about what is happening in your client's home country, and your expert hasn't either never been to that country, is not have a way to, other than their own readings, to testify or explain why they're including that in their report, then the judge can question why that piece of information is there, right? Because that's stepping outside of their expertise. That's stepping outside of what's shown in their resume. So let's dive into mental health experts. So as I mentioned, your mental health evaluation can be an incredibly important piece of evidence in your immigration case. I have had judges multiple times in their decisions granting a case actually quote, actually Rosalie right here next to me, and other mental health experts that we've used in their decisions. So they have stated the mental health expert says blank in their granting of asylum in other cases. And so I truly and sincerely mean it when I say that it can sometimes be one of the most important pieces of evidence, other than the client's declaration, that you can have in your immigration case. And so the great thing about a mental health evaluation is that it can be used to prove many different things. For example, with an asylum case, everything that I'm listing on the slide has to do with key fundamental elements to show eligibility for that type of relief. For asylum, we have to show past persecution or fear of future harm or persecution. the lack of ability to relocate, that there were extraordinary circumstances as to what if you filed after 1 year. All of those things, depending on your case, can be proven up using a mental health expert or a mental health evaluation. For VAWA or VAWA cancellation cases, it's very hard sometimes to prove that somebody has suffered extreme cruelty. But a mental health evaluation could be a key piece of information, of evidence in order to do that.
And that means that there would be details in both the asylum case or the VAWA cases, the details of past persecution within a relationship, the details of their fear of what will happen to them if they leave, if they stay, if whatever, if they try to get help. All of those details come within the context of understanding the psyche of the individual that you would find supports the case.
Exactly. And in that, whether you're working on a VAWA case or a waiver and you're trying to show hardship if somebody has to return to their country, yes, you have the country conditions reports, but you're trying to show how personally for this one individual that can play out. And so your mental health expert can make those links between what the client is saying their fears are about returning to that country and the current either mental and state of the client. It can also be incredibly helpful for competency hearings when it comes to explaining the decision-making of one person and their credibility. We're going to pause before we move on to the next section and just see if there's any questions at this time.
And you can ask questions either through the group chat. I'm monitoring that throughout our presentation, so you can ask questions through there. Or if you would like to directly ask your question, you can go ahead and unmute yourself at this time and ask your question.
It's really helpful to us to understand. It helps give us some direction and some depth if we can hear from you at the end of each with these questions.
Is there anything in the chat?
So there's currently nothing in the chat. If no one has any questions at this time, please do recall that I'm monitoring the chat, so you can ask questions at any moment, and I will, once we get to the Q&A section, I will go ahead and we can address your questions. There's one question. It says, can I ask my client's therapist to be an expert?
Great question and great transition and actually to the next section. So we'll cover that. Let's get to it right now then if there aren't any other questions.
Right. So, well, you're going to do this part. Right.
So, you know, I was talking about different elements of a case that that a mental health expert can touch upon. You know, and I can't stress enough how oftentimes a mental health expert an evaluation has really helped put into context a client's affect, a client's ability to recall details, and just the way the client presented themselves in front of an adjudicator, which directly impacts the way that adjudicator or judge views their credibility. And so supporting an applicant's credibility is huge when it comes to mental health evaluations. But not only that, as I mentioned, judges, ICE attorneys, USCIS adjudicators, asylum officers, despite what we think, despite thinking the fact that they see survivors of trauma all the time, they are not experts in trauma. They're not experts in mental health. And so by being able to explain the impact that a trauma might have on their memory, on your client's overall well-being, on the choices they make, is vital. Because it keeps assumptions from being made that negatively affect your client. Also, it just creates some empathy around the impact of what somebody has suffered onto their daily life. And diagnoses such as PTSD or depression can really put your client's story into context.
Especially if the expert or the document and or the testimony specifically explains the impact of those diagnoses, the symptoms that are related to those diagnoses on memory, on consistency, on affect, on a judgment, on decision-making, etc.
So Rosalie, we're going to get into the fact that an evaluation is very different from just therapy, but what kind of impact can can it have on a client when they're doing an evaluation? Can it be
Oh,
beneficial for them as well?
Right. I mean, it's very well. Let's just talk about the independent evaluator that the client does not know. And yes, there are situations and possibilities of using a client's therapist to do an evaluation. But for now, let's just talk about the independent evaluation. This is if the client doesn't know, we're going to talk about prepping the client and everything. But there is research, and it's very painful. If it's done well, if you have the time to do it, it's still very difficult. We don't typically in therapy ask a person to tell us the very details of their trauma history early on in treatment. In fact, we avoid that so that they can establish some stability, learn to self-regulate, et cetera, et cetera. But in this case, we have to. So under these situations, however, we find that these evaluations actually help people. And they report that. Certainly, my own experience is that people report that even though it was difficult and painful and they had nightmares from one session to the next, they felt like it helped them. So that there are caveats around making sure that your expert is a person who understands how people can get overwhelmed. But so an independent evaluator can in fact help a person if it is done well. Is that what you?
Yes, thank you.
And of course, if it's in the context of a relationship, it's much easier on the client if the therapist is their therapist and knows them. But there are legal issues around that Jessica will address later.
So Rosalie, in our first webinar, back when we talked about what is trauma and trauma-informed worrying, we kind of talked about the different symptoms somebody might see when working with their client, right? That they're either showing up late, or they start rocking and looking off in the distance, or they remember something one day and they can't remember it the next. Can you talk a little bit about how those things that we see, those symptoms, actually combine into the bigger picture of mental health and diagnoses?
I hope so. So this is, so first we want to make a distinction between symptoms you see in the room, or symptoms that might be their behavior or their judgment or their decision making, or things like they didn't show up for their next appointment and you think it isn't only because they don't have transportation. You think maybe they were overwhelmed from the previous experience of talking to you, even as the attorney. This is very, very frightening to them. So frightening and overwhelming emotionally. But those are symptoms, right? Symptoms of not being able to remember, or remembering when they don't want to. Symptoms about their affect, right? Mood, depression, anxiety. So let's talk diagnoses are a series of identifiable criteria in a manual in psychiatry that identifies people's, in a way professionals can talk about the primary problems that the person has. But trauma survivors, particularly people who have multiple traumas over their lifetime, which is many of our people have multiple multiple diagnoses. It's not just that they come up with depression or even just post-traumatic stress disorder. Although those are the two primary ones. We have something that is not in the diagnostic manual, but it is a kind of assumed and agreed upon set of diagnoses called complex PTSD, right? And that is people who have multiple diagnoses. And that means they have multiple symptoms that cover a variety of areas of their inner life and their psyche and their experience of relationships in the outer world and their capacities to work and fulfill daily living tasks. So we have the primary diagnoses that you find in many trauma survivors, particularly ours. There are many, many more that related to the body, related to substance abuse, et cetera, et cetera. But these are the ones you're going to see in many of our clients.
So I think the great thing about working with a mental health expert is they are able to provide that link. right? So we as the attorney might see our client coming in with memory issues. We might see that when they start talking about horrible things, they actually, they don't cry, they present with a flat affect. I have even worked with clients, particularly some of my younger clients, that start laughing, which is, you think, how is the judge going to respond to this?
No, a lawyer thinks, how is the judge going to respond to this? Which is why it's so important that the lawyer help the clinician and educate the clinician about what it is they're concerned about.
Exactly. But the great part is that your mental health expert can take that, can take the impact of the symptoms that you're seeing when working with your client, and really put it in context and draw those links between that and a diagnosis. And not only that, but they can also take the diagnoses that sometimes for the layperson, we might not know what it means when somebody says that somebody's presenting with acute stress disorder or dissociative disorder, and draw the link between the two so that the adjudicator and us, the attorneys, can fully understand what it means for the client. And then we, as the attorneys, can take that and use it when developing their case and show how it makes somebody eligible or how it's evidence for different eligibility requirements.
So I think historically, the diagnoses have been so primary, historically in forensic evaluations. In the recent past, because of the complications in immigration law and what's happening in our culture, the impact of the symptoms may be the most important thing you're going to be looking for or asking your expert to explain.
Great point. So we've covered generally what you're looking for and how it can play into your case on a surface level. Now let's talk about who can be an expert. The first thing I want to say before Rosalie kind of provides more details on the slide is this is not a comprehensive list of all the different licensures out there. So if your licensure is not on here, please forgive us. And for attorneys, this isn't it. This is just kind of the surface level of different licensures and degrees that you may work with. So just keep that in mind, that there's not one bucket of all mental health professionals.
No, but this is pretty much the bucket. So, but what we want to emphasize is these are clinical people, clinical meaning people where mental health is their area of focus. So we're looking at these licensures above, and it's a group primarily grouped by social workers in general or generalists, but there are clinical social workers, and we can explain some of that in this slide. Licensed professional counselors, that's the LPCs. PhD psychologists, which is so social work, licensed professional counselors, psychologists, and then medical doctors who are psychiatrists. That's the four basic groups of mental health clinicians. Under those specific degrees, as you see, the MSW is the degree in social work, master's in social work. LMSW is a licensed social worker, but she has not, or he has not yet, does not have a clinical license to independently practice. And so the list of things that they can do is on the left. However, an LCSW is a licensed clinical social worker who has proceeded to get supervision of 3,000 hours or some period of 3 years, who is authorized to assess and diagnose and treat, and very specifically mental health is their area, and they can independently practice. This is true of a licensed professional counselor. There are other licensures as an LPC as well that are not independent practitioners who are not able to diagnose yet. PhD psychologists, again, with a doctorate and 3,500 hours of supervised experience, they can assess, diagnose, and treat, cannot prescribe. No one else can prescribe, at least in Texas. And there is some discussions about this changing over time with psychologists. other than MDs and psychiatrists, prescribing medications to treat mood and some criteria around PTSD as well. So those are the 4 degrees and licensures. Now that does not cover areas of specialty with regard to trauma, but they do help you look at who you're looking for to start out with.
So Rosalie, you just mentioned expertise in trauma. So are you saying that anybody in any of these categories could technically be an expert in trauma, or is there a connection between a specialty and a licensure?
In general, the kind of specialty in trauma that one gets to have a subspecialty is achieved independently after one's primary education. Now that doesn't, we all get a general overview of trauma, but trauma is very complex. It affects every area of one's internal experience in the psyche and one's life in general. It's generational and multi-generational, and that degree of expertise has to be achieved later. So that is beyond license and degree.
So moving beyond license and degree then, I think it's also important, and this is something that attorneys sometimes forget, is that somebody with the same licensure might have a very different role in your client's life. For example, you can have somebody who's a licensed clinical social worker, and they can be the evaluator in your case. Their purpose in terms of in the life of your client is solely to provide the mental health evaluation at the request of the attorney. Somebody with somebody who is a licensed clinical social worker could also be the therapist or clinician in your client's life. So they could be serving that role, or they could be a caseworker and providing case management, helping connect with social services needs,
particularly in LMSW. Or there are social workers, master's level social workers who are caseworkers. There are bachelor's level social workers who are caseworkers, but it's different. And they would not be necessarily doing the forensic.
So
necessarily.
What we want you to get out of this slide is the fact that you can't make assumptions about what the role a mental health expert or professional has in your client's life solely by the degree they serve. Some licensed clinical social workers practice on a macro level, some practice on a micro level. They are experts in policy as well as case management sometimes. So these are questions and things you have to ask to know, and not assumptions that us attorneys should make.
Right. So when you're asking about your case, specifically about the kinds of traumas the person, you also want to be able to ask the evaluator if they feel like they have a specialty in the impact of trauma in these kinds of ways. Even if it's just adults versus children, for example, you want an evaluator who really, really understands how to evaluate traumatized children. And that is much, very specialized. And for example, I don't evaluate children because I feel like I would need to know much, much more and have much more experience evaluating children, especially young children. And there's a lot of young children being evaluated now. So
at this point, we've talked about licensure. We've also talked about the different importance of having certain expertise and the different roles a mental health professional can play in your client's life. Is you can see, kind of like I talked about earlier, what is an expert or who can be considered an expert. Those are there's some similarities, right? The judge is going to look at the licensure, the experience, the trainings they have. And so these are all things that you should be aware of, not just so that you're able to best present your expert to the judge, but also so that you're making the right choices moving forward in your case, which is what we're moving on to next. And so we had a great question about a clinician or your client's therapist providing a mental health evaluation on the case. So before we dive into that more, let's look at let's distinguish what a forensic or mental health evaluation is from something like a counseling letter.
Well, so she's mentioning a counseling letter because here locally, when you often use the treating clinician the therapist that the client is seeing to provide a letter which looks, in fact, and can be an extensive evaluation of the client, but it is in the context of knowing that client and the relationship between them. So that you call that the counseling letter versus a forensic evaluation by an independent practitioner. So this slide makes some of those, defines the specifics of both of those, right? The purpose, the forensic is to provide the expert opinion with evidence, and the purpose in a clinical setting is really healing and treatment. So the evaluation would be an extension of that, and it's an extension of its purpose, right? Yeah, go ahead.
So I've used counseling letters in a variety of different ways on my cases. Sometimes it's just to merely prove that the person is going to counseling. And that in itself can be part of the argument that, see, they have suffered some sort of trauma because they're seeking, they're speaking with their counselor at a DV organization or clinic because of it. So that in itself can have a value in your case, depending on what you're trying to prove and what type of case it is. I've had counseling letters that are 1 page long, just certifying that that person's receiving counseling. And I've had counseling letters that are 7 pages long because the counselor is an expert in domestic violence, for example, or sexual assault, and is talking about the dynamics and the sharing their expertise on that subject and the impact of the cycles of domestic violence. So it really depends on who the clinician that your client is working with. But I think that the crux of it is the relationship that exists between the client and the person who they're working with. For an evaluator, it's their purpose is to be an evaluator, as Rosalie said, versus their relationship with that person as a therapist. And we'll cover this more in the later webinar, but something to think about is you're going to have to explain to the judge or the adjudicator how that person comes about giving their expert opinion, right? So for an evaluator, in a forensic evaluation, it is a set period of meetings solely for the purpose of doing this evaluation. With counseling, they could be a weekly meeting over 2 months, and that's a lot of information that you're now potentially opening up for cross-examination, for example, if the person is in immigration proceedings. And so those are things that you have to think about. What are you opening up? What are you opening the door to when deciding what kind of evidence you need or what you want to use?
But also you want to, it can go either way. So you would want your evaluator to be able to explain that there are advantages to knowing this client this well in terms of actually doing an evaluation and the impact of trauma. Because of the nature of trauma, it's really, really much easier on the client, and you get a little more depth if you know them for longer. So it can be that can be explained in a very legitimate, not to use a legal language, way that the evaluator could really be able to do a very in-depth evaluation. Now, could the court decide there was bias? And I guess even then, the testimony, the clinician could say that the bias is the professional responsibility of the expert to treat the patient based on their experience, because that is our job, and could in fact support the case yet again in testimony. So it doesn't have to be that only the independent evaluator is not, because they don't have bias, it just depends on how you explain it and how your expert explains it.
The other thing to think about is that with the purpose of the relationship between the clinician and the patient being about treatment and healing, if the client is not ready to talk about their whole story, then it's the patient who's setting that case. Isn't that right, Rosalie? Versus an evaluation where the client is going in knowing, I need to tell you my trauma history because you are writing a report in these set number of meetings for the purpose of an adjudicator. And so there's a difference of not just purpose, but what a professional might be willing to do in a relationship because, you know, if evaluator knows they need to get the information because that's what they're hired or tasked to do and the client consents, that's separate from saying my role, my professional role is to provide healing and treatment, and we will go with those ethics in terms of moving at the pace of the client. So those are all things to think about when whether you can, you know, the person who's treating your client is actually the best person to do an evaluation. And oftentimes, in my experience with my cases, the answer is no. Unless a counseling letter is enough, unless there's not really testimony, then oftentimes I keep those roles separate in my client's life, because it also allows the clinician and the therapist to serve that supportive role and only that supportive role without confusing all those different pieces for my client.
Now, counseling, the counseling letters, how often, or is this even an issue, do they testify?
Well, I specifically, I don't usually call them as witnesses.
That's what I thought.
So yeah. I haven't ever had them because I've never set that up to be a possibility. If I've included a counseling letter as a piece of evidence in a case, I have not included them on as a witness to do.
And is there a reason that you would choose not to?
Well, part of that, you know, I when I'm choosing an evaluator, and if I know I have to go to court, that's something I'm thinking about when I'm choosing who should be the evaluator. That doesn't exist, and it's not the same thing when somebody is finding who their best counselor might be. Those are two different relationships, and so they might not have the same expertise or qualifications because the purpose is different.
Right.
And again, something I touched on earlier is opening that case up. You know, all that information that somebody might have about the client over, you know, months of working with the client to cross-examination. And there's a strategy part for attorneys to think about before doing that. So Rosalie, do you want to talk about what conducting an evaluation actually looks like?
Yeah. So this is the kind of gold standard that we try to reach. And there are many situations where we don't get the gold standard, but we're going to just talk about the ideal. And the ideal is patterned after Physicians for Human Rights historical development of forensic evaluation in immigration cases. But so ideally, it's done over multiple in-person meetings, right? There are many clinicians, and we might not have an option not to, who would do it in one meeting. But in the ideal sense, this is particularly so as not to overwhelm the client. So at least 2 sessions, sometimes 3. I've done it in more than that. This is certainly having the ideal length of time before the deadlines. This is having the ideal ability for the client to come to wherever the organization, where your office, the clinician's office, or however. But I do it at 1.5 hour sessions generally, over 2 to 3 sessions. This is designed to assess, evaluate, and diagnose, right? If the licensure allows. It builds in time you want to build in time after the evaluation for edits and drafting it. This is in the ideal world, it's a very long document, and it covers the whole person's life. It is a thorough psychosocial evaluation as we know them. And you want some time to review it with the attorney before the deadlines. So you provide this written document, the clinician does. The name of the evaluation depends on the licensure and the comfort of the evaluator. So, for example, social workers are not allowed to call it a psychological or a psychiatric evaluation. So we call them mental health evaluations in general. Language. Oh, and of course, for most of immigration cases, these evaluations are done, for many, using an interpreter. I do not speak another language. I always have to use an interpreter. In the early years, there were many African languages and dialects that we had to have an interpreter for. And having an interpreter that is professionally trained to be an interpreter is the ideal. We don't always get the ideal, but we're going to talk a little bit more about that later.
But
Is there anything
for
else?
the attorney with the language, just keep in mind how when you work with an interpreter, it adds time to things, right?
Lots of
So
time.
if you're working with a mental health professional who does speak the same language as your client, that factors into how much time you need. And so the next couple slides go into the elements of a mental health evaluation. I want to make sure we leave enough time for questions, and we're running a little tight right now.
Oh, okay.
And so, Rosalie, I know we can cover this a little bit in our future webinar, but you know, these are just some of the general kind of the way you set up your
Right. And
mental health
the way
evaluation,
PHR
right?
does, the way Physicians for Human Rights, this is right out of the classic format that Physicians for Human Rights uses. And again, they're the gold standard. So the case information, the demographics, who they live with, where they live, whether an interpreter is used, what their primary language is all in the case information. The clinician examiner's qualification. Now, this is very important, that this is a small bio, basically, that's going to provide the court with information about the specialty training that the clinician has with regard to that case. Specifically trauma, but it might be that it's a domestic violence case. It might be that it's an LGBTQ case. And if that person has credentials related to that, that's very important. Or, you know, publications, anything that would strengthen the qualifications of the clinician. Pre-trauma history, what happened before. In asylum cases, historically, you know, if somebody was captured by the FARC, for example, their pre-trauma history would be very different than some of our cases who have been living in a traumatic situation under gang members for years. But the pre-trauma history has to do with family and work and education, medical and psychiatric histories. Current psychological complaint is always important because it's really telling the state of the person at the time of the interviews, right? And that goes directly to the impact of the trauma, because they're waiting, they don't know what's going to happen to them, they're anxious, and all of, not just about what happened, but about what's going to happen. And you get a lot of that in your forensic evaluation. And then, of course, the very specifics that are related to the case about their history. So torture was the early, you know, most of the people in the early days were tortured for political reasons. Now, of course, torture has new, broader understanding. If they were tortured in a domestic violence situation, if they were tortured by gang members, or if they were, et cetera, et cetera. But what is the specific traumas that are related to the case? How does the person understand its impact? How do you understand its impact? How is the person treated differently, et cetera, but in their lives because of it? Everything that's related to their psychological experience of the trauma, their physical experience, their interpersonal experience. You're going to come up with things that maybe the attorney's never heard about before, which will help the case. System questions. These are the extended explanations that relate to symptom, diagnosis, I think they mean symptom, and symptoms and diagnosis that affect things like everything that would relate to credibility, everything that will relate to past persecution, future persecution, harm, et cetera, et cetera. So that would be memory, that would be consistency, that would be ability to give details, et cetera, et cetera. So you want that in your evaluation. Mental status, these are generally a standard mental status exam, very basic mental status exam that helps us know that it is what happened to them, not that they have some serious mental illness underneath, although some people might. Clinical impressions and observations. We want your evaluator to directly relate by the clinical impressions and their evaluations how the symptoms and the diagnosis are impacted by and a direct result of their trauma. And the trauma is, of course, what we're talking about with regard to the case. Recommendations are very important in a standard forensic evaluations. Recommendations for therapy, recommendations for other evaluators, country and or medical, for medication that might help them, et cetera, et cetera.
And so that's something that we'll talk about in future webinars in terms of how the recommendations can play out in immigration court. But in addition to the interviews that you do with the client, Rosalie, these are some additional assessment tools that you use when writing your evaluation.
Now, historically, they didn't use a whole lot of assessment tools. I think they can be very supportive. These are standardized scales, like many of us have been exposed to at some point in our lives, but these are specifically used often, or they're in the different languages sometimes with international populations. And these are just a few of them. There are certainly other PTSD scales, for example, that are Spanish and Spanish languages and others that can be used to corroborate and support the observations during the interview and the clinical recommendations and the connections that the clinician makes. But they are corroborative.
And they help also, to tie it back to the earlier part of the presentation, when what is an expert in terms of who the judge might find to be an expert, also looks at the procedure of how they came about their expert opinion. And assessment measures like this can be used to show this is the process and how they came about with that expert opinion. And so now in this presentation, we're going to get into actually working with your specific mental health expert in your case. We're going to keep going and kind of combine the questions of the last section with the section to come, just to make sure that there's enough time to get through everything. We just like to talk about this. And so what I want to start with is talking about considerations when choosing your expert. And so at this point in time, you as the attorney have looked at what your client needs to show to qualify for whatever type of case they're doing. And you've decided that whether it be to show the past persecution or the hardship they would face if returned, whatever it is, their credibility, you're worried how they're going to testify, you've decided that you need an expert in your case. And so now that you've made that decision, these are all the things that you as the attorney should think about and know before you even reach out to find somebody. You need to be able to articulate and know what's the evidentiary purpose of the evaluation. Oftentimes it's more than one, which is great. So once you know that, then you can start going into what's the particular expertise that your evaluator would need to have in order to provide that expert evidence on that specific purpose. For example, did your client suffer domestic violence? Are you trying to show and answer the question that the judge might ask of why somebody stayed in their relationship for 20 years? Or why they didn't try to leave earlier, or why they felt like they couldn't. I've had cases where Rosalie has talked about the sitting duck syndrome and how the client couldn't leave, right? So her evaluation was able to put into context both my client's decisions at the time and how she felt now, and also help prove up the fact that she was a survivor of domestic violence. You need to know this because it depends on what expert you're going to look for, right? You can't ask somebody who doesn't specialize or have expertise and can speak about confidently LGBTQ issues if that's what your case needs. So this also might mean that you need more than one expert in your case. And obviously this is the ideal. We all live under a time crunch and a financial crunch, especially if we work on pro bono cases or at a nonprofit. But depending on all of those things, it might mean that you need two experts. You have one expert talking about the mental health piece, one expert talking about the country conditions. For example, an LGBTQ case, your mental health expert could link together the impact, the psychological and physical impact of feeling like you can't live your true self, of the harm and long-term effects of either the beatings or physical abuse that they suffered because of it. And your country conditions expert can talk about how LGBTQ issues are regarded in the country of origin of your client. And you as the attorney are taking those two experts and putting them together to present your case and how that client should be eligible for asylum and protection under U.S. law.
Particularly where there's psychologically so much fear of future persecution, even if there has been some in the past, they may be terrified of what's going to happen in the future. And both those experts could help you support that part of the case.
Exactly. Keep in mind with asylum, for those who practice asylum, we're trying to show the subjective fear and the objective, right? So the subjective is where your mental health expert comes in, right? This person does fear, they're credible in what they're saying that, and it makes sense. The country conditions expert can also talk about objectively, anybody in that same position would be fearful because of the conditions
Right.
of that country. Lastly, you should know the particularities about your client. As Rosalie mentioned, the age can affect who's willing to do an evaluation. Is your client comfortable talking with somebody of the opposite gender? Do they have any physical or cognitive disabilities or issues that might impact their ability to do a forensic at this time, or might require you to find a certain specialty?
A specialist who would be able to evaluate competency issues that are related to those kinds of cognitive things. But the other piece is, you want to know if your client's in detention. We haven't mentioned that, but that's a whole other ballgame in terms of making sure that you have an expert who is, one, willing to go to, able to do it in that context, which is very different than the privacy of your office.
Right. You also need to know if you want or need a diagnosis in your case. We already talked about licensure and that some mental health professionals are not able to give a diagnosis. So you need to decide as the attorney if you think that is necessary in your case. You need to know if live testimony is needed, if you plan to call them for court, what the timeline is, when you need to have the brief done, how are you going to be able to give yourself enough time to combine a final evaluation, which plays into if it's a detention court, right? You need to know what you are able to work with so that you can communicate that effectively with your potential expert. It's also helpful to know, if you're the attorney, what other mental health professionals are working with your client. We already talked about the different roles somebody might have. This is helpful because maybe you know they have a good relationship with their counselor, and you know what, there isn't time to do a forensic evaluation, and so we're going to get a counseling letter instead because that's what we have time for, and we make do the best we can with what we've got, right? But you need to know that so you know what options you have and can prioritize your time and your client's resources, whether it's their time or finances appropriately.
And the resources of the expert. I mean, you can't, if you call an expert and say, I need a document next week, you're going to find a lot less experts who are able to do that, particularly if they want to do a full forensic evaluation. Whereas if you know the timeline of the case, and sometimes attorneys don't know. They get the case the last minute as well, which makes it very difficult to do any of this.
Now, we've already talked about interpretation needs and its impact, and touched a little bit on resources. Can your client afford an expert? Is there funding available? Are there grants available? Does your location have any kind of stipends? In Houston, thanks to the Houston Immigration Legal Services Collaborative, there are some stipends available. This can be kind of a sensitive topic sometimes because it is important to keep in mind that your mental health professional that you're hoping to work with is exactly that, a professional with a job, with clients, with bills, and a business to run. And so, everyone is doing their best to help survivors of trauma, but it's something to keep in mind. And lastly, are there any other barriers, whether it's transportation or safety or health, that could affect your client's ability to even do a forensic evaluation? I've had clients that, even though it was incredibly important for their case, they just weren't there. They weren't there where they could go through a mental health evaluation.
They couldn't tolerate it, you mean? They just couldn't. And they might not know that, they might not say it to the attorney, but their behavior, they may not show up, they don't show up for the next appointments with the attorney, a variety of different ways where they find themselves avoiding, but they don't know that's what they're doing. And that's also to be explained by a mental health expert, why they wouldn't understand that they were really not able to do it.
And lastly, Rosalie touched on this, detention. Detention throws a wrench in everything. And so is it possible to get a forensic examination done or a mental health evaluation done in detention? Yes. Is it easy? Not a chance. It is very challenging. And so I don't want to minimize how many barriers that itself can present. So so you don't have to listen to us to keep rambling. We actually have some great video clips, thanks to Chloe and Marissa, that helps illustrate some of what we're talking about.
Good afternoon, this is Chloe.
Hi, Chloe, this is Marissa. How are you?
Hi, Marissa. I'm good. How are you doing?
I'm great. I was just calling to see if you could help me out with a mental health evaluation for one of my asylum cases. I'm always looking for good social workers and counselors to help with these.
Oh, wow. Thank you so much for thinking of me. I'm not sure I have the right background to help you. What kind of case is it?
It's an asylum case. My client is an 18-year-old woman from Honduras who suffered multiple sexual assaults, forced relationship, domestic violence, and who had 2 children with her abuser before she escaped.
Wow, that sounds like a really compelling case. All of my experience is in end-of-life counseling for the terminally ill and their families. So I'm not sure I would be the best fit for your case. I don't really have a lot of training in trauma of the sort that your client has experienced. I do have a colleague whose focus is on trauma and specifically working with survivors of sexual abuse. I could put you in touch with her if that would be helpful.
Okay, that sounds great. Thank you.
All right, I will do that. Have a good day.
Thank you.
So I think this blurb helps us explain a couple things, right? We just talked about the things that you as the attorney should know before even trying to contact a potential mental health professional. And some of that was modeled thanks to Marissa in terms of the knowledge that they're able to communicate off the bat. Because now that you know what you need, you're able to see, is this mental health professional a good fit as an expert in my case? Rosalie?
So clearly she was calling kind of a cold call to a clinician, hoping that she would be an expert, hoping that she would have this expertise. So first, you would ideally want to call an expert who had been trained by PHR or some other training like we do here in Houston for people that are really based in Physicians for Human Rights historical trainings. And because we're so close to the immigration border here in Houston and the court, we have developed some trainings for people specifically to do mental health evaluations for the court. If they haven't had that, then there are other specific trauma-related education training and referral sources, so you're not having to cold call if you don't have to. And some of those will be on our website, I think, for referrals for people who have some kind of training in trauma.
Right, but the reality is, in an ideal world, you would have access to this. And if you don't, sometimes you really do need an expert. And so you are making those cold calls. And so to best use your time and to respect the professional's time, you need to be prepared and have thought through all those things the last slide talked about so that you can engage in this conversation that we're about to talk about with your potential expert. I think the most important thing is just to be frank, open, and honest. You want to get everything out on the table now in terms of what your needs and expectations are, so that it's not during the evaluation process or afterwards when you're looking at the report and it doesn't really actually help your case very much, because then you've wasted your time, your client's resources, and the professional's time. So when talking to your expert to decide if that is a good fit for your case, make sure you're talking about the purpose of the evaluation. The mental health professional should know what type of case they're working on and any particularities that you've already identified. You should confirm that your evaluator knows about trauma and depression and disassociation and the impact of trauma on memory, if that is what you need your case to cover. Remember what Rosalie said, not everyone is an expert in all things when they're a mental health professional, right?
Right.
You need to communicate whether you think testimony is needed from the beginning. Some individuals will not feel comfortable testifying, and that is okay. So if you need it, you need to communicate it from the beginning. This will definitely affect who can be an expert in your case. And maybe at that point you decide, either because of time or other issues, I'd rather have an evaluation and maybe not have live testimony, knowing that the lack of opportunity to cross might impact the weight the judge puts on the case, but it doesn't change the fact that it could still be submitted as an expert evaluation.
But also, if you tell the person up front, the clinician, that there's testimony needed, and you reassure them, one, that they're an expert, and two, that you will prep them. You will not leave them hanging out to dry, unprepared to go before the judge. And that makes a huge difference to clinicians who have not had a whole lot of experience testifying.
Great point, Nikki. Which ties into the next one. What is their expertise during evaluations? You know, that's something you need to know, because you need to know how much time to budget for prep, right? And be able to work, because you want your expert to feel as comfortable as possible when facing the ICE attorney. Of course, you need to know the schedules and deadlines and timeline of everyone. Sometimes us attorneys, when we're working on our case, we're focused on our own timelines and deadlines, but there's more than one professional in the room with different deadlines and schedules. So we have to make sure it works for everyone. And whether the evaluator feels like they can be an expert in your case. And some, you know, if they feel like there's a reason why they're not a good fit, allow them the opportunity to communicate that. You're explaining to the judge why this particular expert is an expert in this particular case, and your expert has to feel like they are. And so be ready to ask and give the opportunity, and be open to the response of, I might not be a good fit for your case. Lastly, we can talk about this more in a future webinar, but if there's some kind of particular format you prefer as an attorney, communicate that ahead of time, not after a couple drafts have already been written. Yeah. I personally don't have a specific format. I like, you know, but some attorneys prefer having numbered paragraphs, yes, for example.
Yeah, and we're not used to writing it in the kind of paragraph form that a brief might be written in. Is that right?
Exactly.
So, and I've had some attorneys want me to put it back into that format.
So you've thought about all that you need in the case. Now you've reached out to somebody to ask if they think they're a good fit as an expert in your case. And so at this point, if you've agreed and that person is a good fit, the communication is not over, it's just beginning. Affidavits or case summaries. Some people like to provide affidavits or case summaries to the evaluator ahead of time, others do not. You know, they can be really helpful, especially for things like spelling of names and places and things like that. My personal preference is now, because of questions that we've been asked in the Houston immigration courts, is not to provide the affidavit. But to provide just a case summary. But that's something that we'll talk about in future webinars. You want to discuss the trauma level that the detail level that you need about the traumatic events. To put that in context about what this means, Rosalie talked about how a lot of the people we work with have suffered complex trauma, right? They have a lifetime of trauma sometimes, but all of that traumatic experience, while maybe goes to hardship, maybe helps explain affect or the impacts and the symptoms, might not actually be what you need the evaluation to focus on. For example, if you are working with a client who maybe suffered childhood abuse in a violent household, but you're working on a trafficking case and you're hoping that the evaluation will help support the fact that the person is a victim of a severe form of trafficking, 4 pages of the 7-page expert report should not be on the childhood trauma, right? It is relevant, and obviously the expert will get the whole trauma history, as Rosalie talked about, but it shouldn't be the primary focus of the case or of the evaluation.
And the evaluator has to know, you know, if it's a trafficking case, that, you know, that's very important. Now, you might want the evaluator to give enough of the trauma history prior to that childhood trauma to help the court understand their vulnerability to the traffickers. However, the trafficking experience is and the trauma and its impact, even when it's cumulative and on top of childhood trauma, is very important to be focused on and not confuse and or distract by the first 4 pages of a complex trauma, which is what has happened, and I've done it. So, yeah.
And so something else you want to make sure you talk to your expert about is the impact of inconsistencies on an immigration case. It's hard for those of us who don't go before a judge or don't see how it can play out to truly understand how small details really can be used against a survivor to torpedo their credibility in court. And so, if that is a concern that you have, you need to talk to your experts so that they understand to really spend time in their evaluation connecting those dots, the symptoms they see, the affect they see, and how it is normal and expected, not an indication of lies or fraud.
Right, of intention and or even of conscious awareness, because the attorney may say, well, she said it happened in January, and she also the next time said it happened in February. She doesn't really know when it happened. And you want to be able to explain, if that is addressed at all, you want to be able to explain to the court that trauma memory is inconsistent. And the client might not even know that they reported inconsistently.
And that's also where it goes to talking about details, right? That's where you can tell your evaluator ahead of time, please, if the client has a hard time with set dates, it can really impact the way the judge looks at their case. Where possible and where you feel comfortable in your expert opinion, please avoid using set specific dates, right? As attorneys, we all the time say on or about August 2019, or we, in the first half of 2018, right? Where we can, put things in context. You should communicate with your evaluator so that they can do the same thing.
Yeah, because the evaluator isn't used to that. So you have to explain that it would be really much easier in the court situation if we're not to avoid saying specific dates, and to explain, as Jessica did, to your evaluator on or about, rather than the language of specifics.
So we're going to move on a bit, but the one thing I want to touch on this slide before, two things real quick. One, discuss the importance of drafts. If there's going to be back and forth, you want your evaluator to know that ahead of time so that you guys can feel comfortable. And that ties into this last point that I want to emphasize for the attorneys on this call. Remember that the evaluator is a professional and an expert in their own right and should be treated as such. That goes with drafts and what edits you're asking them to make. They have a professional opinion, they have licensure, they have ethics and code of conduct. So keep all of that in mind when making edits. It's completely logical and natural to ask them to take out, maybe focus less on here, or ask them to focus more here, or say a few more details or explanation would be very helpful for a layperson in this area. But you're not asking, as long as it's understood that you're not asking them to change or amend their expert opinion.
Right. The edits are really about punctuation and about those kinds of things. They're not edited. You are as the attorney are not editing it. You are just merely saying what's important here and what might be less important. And could you tell me more about this or that?
And be open and honest. If your evaluator values the second set of eyes as looking for grammar or spelling error, great. But that's a conversation that you guys have ahead of time. So we're going to move on now that you have your expert, now that you've talked about what you need and they're going to agree to do the evaluation, how to set it up. And so there's questions about who should be in charge of setting it up, whether it's the client or the attorney. In our opinion, where possible, it should be the attorney. There are practitioners that have the client do so. But keep in mind, all that information that we just talked about, it's important that you communicate to your expert. And it's really, really challenging to expect your client to actually do that.
And it's challenging to expect the client to successfully find someone if they don't know the purpose and the evaluator doesn't. So it's just a recipe for not getting what you really need for the case if you don't find the person, set up the evaluator, give them the information, etc. and help the client understand its purpose.
So Rosalie's right. At the end of the day, if the attorney sets it up, it really saves everyone time.
Everything.
The attorney and the client and the mental health professional. Also keep in mind the incredible stigma there is against mental health in this country and in other countries around the world. So even just calling somebody up to ask for a forensic evaluation for their case can be an almost insurmountable step. And you already decided that this is a critical piece of evidence in your case. Why make it harder to get? So skip it maybe. We're running a little bit short on time. We have another great video that shows how somebody can actually set up an evaluation really well. We'll make sure it's sent out at the end of this PowerPoint so that you guys can watch it. I recommend you really watch it because you can see how calling and setting up and having this conversation really does set you up for success. So you've prepped your expert. We've talked about the attorney calling to set up the evaluation. Now it's important to remember to prep your client. So we talked about in the first webinar we did on trauma and trauma-informed lawyering, the impact it can have on your success and your ability to work with your client to make sure your client is informed on what's going on. And the same is true when it comes to a forensic. A client should know what is a mental health evaluation or a forensic evaluation and what to expect. As Rosalie touched upon, it can be incredibly traumatic to all of a sudden go and have to tell somebody they've never met in an hour-and-a-half session the worst that's ever happened to them, right? It's traumatic in itself. So they should be prepared to know what they're going to be expected to do and why. This ensures that you'll actually have the mental health evaluation completed, because otherwise, it's very possible that the client will not be in a state of mind to be able to work with your expert.
And your attitude about it is critically important for normalizing this experience for your client. So we want the court to understand how these terrible things that have happened to you have affected you in the ways that they won't understand unless we have someone who can talk to you very specifically about how it feels to you, what you thought about it. And it's going to be hard, but we know that you can do it. Lots of reassuring. Sometimes the attachment to you and the trust in you becomes the link to trusting that the client can do this. So you want to really help them understand it's about what happened to them, and that what happened to them can be really explained more clearly with a mental health evaluator, that they're not crazy.
And if you do that, and if you, that goes into what Rosalie talked about earlier about having the evaluation itself have some therapeutic benefit for your client. It can also be helpful when you know what other support systems your client has, because it is a hard process. If they are working with a counselor or a caseworker, maybe the day after, that's when they're going to go see their own counselor, or their caseworker can check in with them to see how they're doing, because it can be such a difficult process. So, that extra bit of knowledge that you have about your client might help set them up for feeling okay after doing something that's so difficult. So we have another great video that actually shows somebody being able to prepare their client for an assessment.
Hey, Diana. Thanks for coming in today. I know we've been working a lot on your declaration, and we've talked a couple of times about how it's normal for those discussions to be hard because of your past experiences. We want to talk to you today about another kind of evidence that might be helpful in our case, and that's something called a mental health evaluation. One of the things we have to prove in court is that you've suffered certain types of harm, including emotional and psychological harm, and that can be hard to explain and hard for a judge to understand. And so a mental health evaluation takes some of the weight off of you of explaining how hard those experiences were for you, and any parts of your story that a judge might not understand can sometimes be explained better by someone who's an expert in how trauma affects a person. So this expert will be someone who's a social worker a therapist, a counselor, or even sometimes a doctor with special training who can evaluate trauma and explain it to the judge.
You want me to see a therapist?
Yes, but I want you to understand that this isn't because there's something wrong with you. Any person who suffered what you did would have symptoms of trauma. That's normal. A mental health evaluation is like going to see a doctor and getting an x-ray of a broken bone. From the x-ray, the doctor can tell how serious the break is and what kind of treatment you need to heal. Does that make sense?
Yeah. Sometimes you need a cast, but sometimes you might need surgery.
Exactly. And that's what a mental health evaluation can help the judge understand, how much your past trauma caused harm, and that's something that's really important for us to show in your case.
Can you just share everything that we've talked about with the therapist?
So if you give me permission, I can share with the therapist a little bit of information about your case, but the evaluator needs to talk to you and make their own assessment for court, independent from the things that we talked about or even what I think of your case. So they can come to their own conclusions. Is there something specifically you want me to tell them about before you meet with them?
That's good.
Can you let her know about the time that I was sexually abused? It might make it easier to talk about it. I know she already knows.
Yeah, I can definitely tell her about that. I know it's going to be hard for you to talk with someone else about what happened to you again. And I'm only asking you to do it because I think it will be helpful in your case for the judge to hear about it from a professional, from a different perspective of what you've been through. I think that you'll find her very supportive and easy to talk to. She's worked with some of my other clients who've gone through similar experiences, and they told me that she was very kind and understanding, even though they had to talk about difficult things.
Will you be there with me?
Unfortunately, no. Part of the evaluation is that you are there to speak just with the evaluator. But if you like, either me or someone from the office can meet you at her office on the day of your appointment, kind of make introductions and make sure you get there okay.
Can I bring my toddler?
I think it will be difficult for you to talk about things you need to discuss with the evaluator if your child is there. It will be better if you had someone you can leave them with that day.
What is this person gonna do with the information? She's gonna share it with the court?
So she's going to write up her opinion in an official evaluation that we'll submit with all of our evidence. So first, she'll send it to us, and we can make sure that there aren't any mistakes in it, and then we'll put it together with your declaration, with the country conditions, with the letter of support that we already got from your mom, and all of those other pieces of evidence, and we'll use that in writing our brief so that we can show the court what you've been through and how you've been affected. So she won't share it with the court before giving it to us.
What if I say something wrong?
That's not something that I think you need to worry about. You are the expert in your own experiences and in your past history of what's happened to you. So this evaluator has a lot of training on how to work with and interview and speak with people who are survivors of trauma. And if there's anything she really doesn't understand, she'll check back with you or with me to make sure we clarify before we move forward and give anything to the judge.
Okay, sounds good.
Okay.
Just let me know where do I need to go?
Okay. Well, why don't we call their office now and see what their next appointment is, and then we can see if that works with your schedule, okay?
So the great thing is that helped illustrate a whole lot of wonderful points, right? Do you want to add?
No, I think it was beautiful. And I think she did such a great job explaining to the client. And then she will proceed with saying, and now we'll make the appointment. In other words, the attorney's taking responsibility for making the arrangements, There wasn't a question about interpreters, but the attorney would find the interpreter in the ideal world, right? So, yeah, it was great.
And I think what that also shows is when you allow your client the space to ask questions, it helps you not make assumptions, right? We might assume as the attorney that the client knows well, it's hard when you bring a child to work with me on your affidavit. So obviously you wouldn't think to bring your child to your forensic evaluation. And that's a mistake on our part to make those assumptions. And so by allowing the space for questions, we can make sure that the evaluation will go as best as it can, because you've set yourself up for success.
But one thing is that many of our clients do not feel free or safe enough to ask questions. So you might want to, they have a child, you might want to say, it's very important that you go alone, and do you have childcare for that day? So that sometimes they don't know to ask these questions or afraid to.
So in the last minute, just a couple other things to keep in mind. Don't forget to prepare your interpreter as well. We talked about, working and setting up your evaluator for success. You set up your client for success. Set up your interpreter for success too. Interpreting for a forensic is incredibly hard. It's a hard work, both mentally and physically. So make sure that they know what to expect as well, so that they're not surprised by what they hear. So the ideal is to use trained interpreters. And don't forget to remind them about the importance of confidentiality. That also means you need to discuss scheduling as well, because if you can have the same interpreter for both days, right, it can make a huge difference in terms of the success of the forensic. And if you can, have some time to debrief with your interpreter, especially if this is an interpreter that you are keeping in your network and want to use for future cases. They should feel supported as well. And make sure you, the attorney, knows who's going to interpret or finds the interpreter, because it is not a good idea for a family friend or as somebody that the client knows to be the interpreter. That will have the opposite effect of setting you up for success.
And Jessica, someone just asked a question that I think is very pertinent for the video we just watched. The question is, should we prep client to diagnose for diagnosis in case there is stigma? So would the attorney prep the client during this conversation and prepare them for any potential diagnoses that may arise from the forensic?
So that's a great question. Should we prepare our client if we think there's going to be a diagnosis? I think that's something that you can say that, if appropriate, if your expert is able to diagnose, that they may do. And again, it's about normalizing things. It is completely normal and expected that a survivor of trauma will have mental health implications from that trauma. That is what we know. We know that trauma, as we talked about, and Rosalie, please take over on this, affects our mind, body, and everything else.
Yeah, but I think it's really incumbent upon, yes, you can prep them, but I'm not sure that many of, at least our more recent clients, would understand the full impact of what that means to have a diagnosis. However, your expert should be explaining to them that these symptoms mean something in the language of medical language, so that physicians and clinicians have a way of explaining to the court what has happened to them and how it's affected them. So these diagnoses have meaning for that reason. And they may hear it when it comes to testimony, because they're sitting in court listening to everything that the expert is going to say on testimony. But it's really incumbent upon the expert to explain those things.
So in addition to, for the attorney's role, in addition to normalizing it, there's something else to consider. I've had clients who, because of their own fears, because of where they were at, or because of cultural pressures, did not feel comfortable going to counseling, refused to go to counseling, did not want to go to counseling. They were willing because I explained to them the impact of the importance of a mental health evaluation on their case to have a forensic evaluation. That was their first experience with working with a mental health professional. And because of that, because then they could see a diagnosis that a mental health professional gave, because the mental health professional and me as the attorney normalized it and put it into context, that same client was later on willing to go to counseling. Which again, it doesn't necessarily benefit their case, but it benefits their life. And part of our jobs as attorneys is, they're our clients, but if we can help them in any other way, that's great. And so that's a benefit to think about as well. If they're worried about a diagnosis, to put it into context and to see how the impact it can have on their life, and an understanding of what is mental health, what are mental health professionals as well.
So I think the bottom line is the client should come away with the notion from you, and you should come away with this notion, and so should the court, that it's not what's wrong with them, it's what happened to them.
So in summary, just things to keep in mind as we're talking about setting yourself up for success in terms of getting this incredibly crucial piece of evidence for your case. Don't forget the open and honest dialogue at every stage and with everyone involved. Remember the purpose of the evaluation, and make sure your evaluator remembers the purpose of the evaluation. Right? This is for their asylum case to prove that they have suffered past persecution and to talk about how difficult it would be if they were forced to return and the impact of that. Right? You're ensuring that everybody is on the same page and moving towards the same goals. That's true when doing edits back and forth. That's true when setting it up, and that's true when wrapping things up. For some people, this is the end of the road. Once they get their evaluation, there's no court. They're going to submit it with their documents to USCIS, and that's it. For others, this is just the beginning of the next chapter, and for us, the next webinars to talk about how to prepare for court. But what doesn't matter wherever the decision part comes, whether it's from USCIS, in some cases multiple years later, or after their day in court, if you can circle back with your expert and let them know what the decision was, right? It's part of common courtesy, and also our lives are touched by our clients, and so are our experts' lives. And so where you can, circle back, let them know, provide feedback, keep an open line of communication, because more likely than not, you're going to need them to be an expert again on a future case. So next steps, I want to hand this wrap up to Talia.
Thank you so much, Jessica and Rosalie. That was fantastic. I also want to say thank you to Marissa and Chloe, who helped us along with this process and did some wonderful videos. Unfortunately, we were not able to play all of them due to the time, but they will be included in the PowerPoint presentation when it is sent out. So please go back, circle back, and look through those videos. They are fantastic and educational as well. So again, this is webinar number 3. We are really happy you joined us today, and for anyone who sees the recordings as well. We are planning to have 1 or 2 more of these webinars, so we are looking forward to adding to your vast knowledge about forensic evaluations and how they work, and how to collaborate with each other. And so we are going to be in the future webinars discussing how to use mental health evaluations for presenting your case in court, prepping your expert for court, both direct and cross, and qualifying your expert in immigration court. So that there's more to come, and we're excited to bring that additional information to you. We don't have any set dates at this time, but we will be communicating with you regarding any upcoming webinars. And hopefully next time we will give you more time, much more time in order to sign up and register. Unfortunately, due to the holidays, it was a big fast-paced system, but we will try to do that, give it more time for you. Here are some additional resources. Again, when we send out the PowerPoint presentation, you will have this information and these resources available to you.
And don't forget, our past PowerPoints and webinars have also listed additional resources. So please do circle back and combine the resources that were provided in other webinars.
And CLE credits are pending, so please do look forward to that as well. And I believe that's it. That information will be sent out by email as well. I don't know if we have any questions. I don't see any on the chat box, but we are essentially out of time. So thank you all for joining us. And
is there a way that they could send the questions in? Should either one of us at some point in the future?
Absolutely. If you have any remaining questions, you can always send me an email. My email is thalia@houstonimmigration.org. So any questions that you send over to me, I can always forward to both Rosalie, Jessica, Chloe, or Marissa. Thank you all for joining us, and we look forward to having you join us in the upcoming webinars. Thank you.
Take
Thank
care.
you, everyone.
Bye-bye.
Happy Friday.